Hi, everybody. Welcome to week 11 of the Legal Environment course. These are the slides for Tuesday, November 7th. Currently recording this on Monday night, November 6th, so hopefully I'll get the slides and this YouTube video uploaded by tomorrow. So the topic of week 11 is continuing our discussion of the courts and their attempt to cope with modern technology. And tonight we're going to be talking about the courts and regulating hazards and the environment. And so last week we talked about the development of tort law and the rise of insurance in the United States and how that affects law and courts and how that has sort of led to a shift in the way that the courts deal with coping with modern technology. So we're going to continue in that vein tonight, only with this different topic area of regulating hazards and the environment. So we're going to think about this in light of a few questions. So the first is that many Americans, polling data shows many Americans favor laws that protect the environment and that promote public health and public safety. Yet, as you should be sort of familiar with by now, Americans are also notoriously suspicious of governmental rules and meddlesome bureaucrats. And a quicker way of saying this is that we have a mistrust of centralized authority. And so this begs the question, are the courts well equipped or poorly equipped to address certain policy issues? And if so, which types of policy issues are the courts not very well suited to address? And are there alternatives to lawsuits? And in the end, can we have essentially too much law? So in order to get at these questions, we're going to look at a few different things. We're going to look at a Supreme Court case from 1935 called Versailles, and we're going to use that as a case study to get at some of these questions. We are going to look at how policymaking and the environment has changed over time, using a hypothetical example that can deal, or that sort of allows us to deal with some of the ways that it's changed over time using a made-up river called the Pioneer River. We're going to look at what courts might do surrounding the Pioneer River and pollution in the 1930s and the 1950s, and again in the 2000s and in our current decade. And then we're going to introduce a new sort of framework for thinking about how the courts can affect policy when it comes to regulating hazards in the environment. And this is called the socio-legal model of policymaking, and it's found at the end of the assigned readings in the judicial policymaking reader that were assigned for today. And then finally, we'll apply the dynamic court view and constrained court view to some of these concepts. Okay, so we talked a little bit last time about the problems with technology with respect to tort law. So today we're going to talk about the problem with technology regarding the environment. And so when we're talking about environmental law, we're using this to describe the interaction between institutional constraints on the courts, which you should be familiar with by now, and the complexity of the modern policy-making environment. And environmental law shows this complexity very, very clearly, and it provides a nice case study for us to get at some of these questions. And so the characteristics of this complex policymaking environment is that risks are ongoing. Okay, so they're not discrete, singular events that happened in the past. Instead, when we think about pollution, this is an ongoing risk. Problems similar to risks are not discrete. And in fact, related to this, the harms are not discrete enough to redistribute wealth. So if you think about the average person, say in Dallas, being affected by particulate matter in the air stemming from heavy industry in Dallas, the average person is not going to be affected enough by particulate matter in the air in order to see a massive redistribution of wealth from corporations to the public. So the big question then is, are courts able to deal with multifaceted cases and disputes? Okay, so when we think about this, and this is sort of similar to our discussion of tort law last week, here's essentially the structure of our analysis. It's got 3 steps: step 1, step 2, and step 3. So in step 1, we ask, what is the nature of the problem? All right. Step 2, we ask, what are the relevant legal tools for addressing this type of problem? And in step 3, we ask, given what we know about the American legal system, is litigation an effective tool for addressing this type of problem? All right. So let's get some definitions on the table before we jump into the Versailles case and this Pioneer River example. Um, so these terms come from economics. If you've taken an economics course, they should be familiar to you, but we're going to be talking about externalities, which are unaccounted for third-party costs. So when two parties engage in some type of transaction or some type of activity, if there is a spillover effect that affects a third party, that is considered an externality. It is external to the original transaction, yet is still impactful. Our second definition that we need to get on the table deals with scarcity. This is another term from economics, and it refers to when demand is greater than supply. Very simple. When more people want a good than um, and that want exceeds the availability of the good. The third definition to get on the table is transaction costs. And transaction costs refer to literally the costs of contracting among various parties. You may be asking yourself, what do these have to do with environmental law? Good question. We're going to get to that in a second. When it comes to transaction costs, though, we see that the law has developed potentially into dealing with lots and lots of nuisance lawsuits. And nuisance suits stand in opposition to negligence claims, which we'll get to in a second. But essentially, because of the number of these nuisance suits, begs the question, do we want judges doing cost-benefit analysis and dealing with the costs and inconsistencies of so much adversarial legalism? The alternative to filing lawsuits for dealing with some of these environmental problems, which again I'll illustrate in just a second, are self-help and settlement, which are two forms of dispute resolution that we've discussed in class so far. And we see that they have their benefits, right? Self-help is mutually accommodating. It can be potentially tailored to the dispute at hand. Settlement, on the other hand, saves parties a lot of resources, considering that the costs of proceeding through the American legal system are so incredibly high that if parties are willing to settle out of court, it can make their lives, significantly cheaper. But the question is, do we really want private parties dealing with self-help and out-of-court settlements to control scarce resources that are ostensibly public? And again, I'll give you an example of these in just a second. And then finally, as a legal system, how do we overcome high transaction costs? All right, so here's our hypothetical example of the very creatively named Pioneer River. And this is an example of what courts may have been dealing with in, let's say, the 1930s. Okay, so we're clearly past the Industrial Revolution at this point, yet courts, as we've learned, were not as adversarial then as they are now, and they didn't have to deal with as much complexity then as they do now. So this particular example illustrates the concept of externalities. So here is our Pioneer River. Like any good river, it flows from north to south. And on the east side of the river, you have a coal mine. And this example is sort of taken from the Versailles case, which I'll talk about in just a second. The coal mine is upriver from a series of small family farms. All right. And like any good coal mine, the mine not only mines and sells coal, but it creates pollution which then flows into Pioneer River and, of course, downriver to where our family farms are located. So families then complain, right? They may want some sort of remedy, but two questions arise when we're dealing with the court regime in, for example, the 1930s. One is, do the families even have the ability to sue the coal mine in order to recover damages based on the pollution that the coal mine sends down the river? And two, if they can file a lawsuit, are they likely to win? And the Versailles case gets at these questions really nicely, which we'll talk about right now. So in the Versailles case, we've got two parties. So the plaintiff in the case, which is the first name in a court case, right? So so-and-so versus so-and-so. The first so-and-so is the plaintiff. So you have the city of McKeesport, Pennsylvania, which is in the middle of coal country in Pennsylvania outside of Pittsburgh, as well as 13 private citizens. The defendant is was the McKeesport Coal and Coke Company. What was the cause of action? The plaintiffs in the case, again, the city and the 13 private citizens, filed a nuisance suit against McKeesport Coal and Coke Company. As for the facts of the case, the coal company owned 2,500 acres of land, making them the biggest landowner in the town of McKeesport. Coal mining operations back then and still today create something called GOV piles, which are piles of waste and debris that tend to spontaneously combust. So when you mine coal, there's just a certain amount of material um, that is, you can't sell, but nevertheless you're taking it out of the ground and it has to be stored somewhere. And so these enormous God piles that from a distance look like actually hills or mini mountains, just litter coal country from Kentucky to Pennsylvania to Appalachia, etc. So the gob piles create smoke, they create dust, and they create odors that the plaintiffs claimed interfered with their enjoyment of the land that they owned. So as for the coal mining company, they never paid a single dollar in dividends to shareholders. They were not profitable, and over the course of their existence, they had net losses of $500,000. The company, however, also on the positive economic side of the ledger, had 413 employees and a weekly payroll of more than $10,000. So the court is operating with these facts. Also important to mention that the case took place during the Great Depression. Sorry for that typo, there was only one depression. And of course, in the Great Depression, as you know, jobs were scarce, people were out of work, etc., and the existence of the McKeesport Coal and Coke Company was seen as really essential to the economic viability of McKeesport, Pennsylvania. So, what were the plaintiffs seeking? We know that they filed a nuisance lawsuit, but they were seeking what we call an injunction, which is essentially a behavioral remedy. What did the court end up doing? Well, the court denied the plaintiff's request for an injunction. In other words, the mine could continue adding to the gob pile, and not only could they continue adding to it, but they did not have to come up with a plan to remove it. So why? What was the reasoning of the court here? Well, they said that the costs of removing the gob pile and treating coal waste differently essentially exceeded the benefits of doing so. And this is something pretty novel. This is the American judicial system, judges in the American judicial system essentially running a cost benefit analysis when looking at how to apply the law. So where is the law here? Well, the law doesn't matter, because what they're saying is that the cost of removing this waste, regardless of whether the plaintiffs had a good case in their nuisance suit, exceeded the benefits or outweighed the benefits of removing it. So what this means is that health factors, economic factors, social, and even aesthetic factors were completely irrelevant, as was the nature of the law. So quick aside on negligence versus nuisance suits. We talked a little bit about negligence last week and how the concept of negligence has evolved over time. And it's useful here to compare negligence and nuisance because these two sort of causes of action really serve to transform environmental law in the United States in the 20th century. So negligence requires plaintiffs to prove essentially 2 points. One, they require plaintiffs to show that the defendants had a duty of care, and then also that defendants breached that duty of care. They also require plaintiffs to demonstrate that defendants acted unreasonably and that the actions of the defendants caused harm. And so typically the courts have determined that negligence suits involve past actions, they involve events that are discrete, and that none of the issues in negligence suits are really outside of the judge's spheres of expertise. I'll talk a little bit more about that in a second. And the core issue of a negligence suit is how much money should the plaintiffs get, if any? So essentially assessing damages, right? So if you think back to how we framed the beginning of this conversation tonight, none of these aspects of negligent suits really fit environmental law, right? We know that environmental problems are not in the past, that they are by definition ongoing, that the events are not discrete, that the events bleed over and are ongoing as well, along with the risks, and that environmental problems often require judges to deal with issues that are outside of their expertise, as we'll talk about in a second. So nuisance suits, on the other hand, deal with potentially cost-benefit analyses that range really broadly. Health, economic, social, aesthetic reasons, etc. Problems are often ongoing. So in this case, the gob pile, in the case of Versailles, was burning. And when the plaintiffs filed the lawsuit, it was burning at the time and needed to be addressed. Events are less discrete, so because smoke from a burning gob pile is airborne, it travels. So there's no way for defendants to say essentially that the nuisance that the gob pile creates is limited to a certain sort of geographic or atmospheric area. And then finally, it involves issues that involve multiple dimensions, right? So economic dimensions, health dimensions, aesthetic reasons, etc. And so the core issue here is not how much money the plaintiffs should get from the McKeesport Coal and Coke Company, but instead what should be done. So the courts are tasked with crafting an injunction, deciding whether or not to apply an injunction, deciding whether or not to make McKeesport Coal and Coke Company clean up the gob pile. Not only that, but what if they can't afford to clean up the gob pile, right? So the courts are having to deal with all of these issues that are essentially really outside of their expertise and what we don't normally tend to see in negligent suits. So this movement from negligent suits to nuisance suits really transformed environmental law, as we'll continue to see here with these next two examples. So if we look, fast forward 20 years as nuisance suits are really coming into play with respect to dealing with the environment. So here, our Pioneer River example gets a little bit more complicated. And we're not only dealing with externalities, which of course, in the previous example was the pollution that the coal company creates, then goes downriver and affects those small family farms. So now we're dealing with those same externalities, but we're also starting to deal with this understanding that resources, potentially natural resources, are scarce, right? And so this is where we talked about when demand outstrips or exceeds supply, right? Okay, so our Pioneer River, again, flowing north to south, as rivers do, in the northern hemisphere at least. And up here we have undeveloped land up in the headwaters of the river. Over here we have a giant manufacturer, which needs water, and I'll get to that in a second. And over here we have a big industrial farm, okay? So the big manufacturer requires lots of water to cool its manufacturing facilities. The big industrial farm requires lots of water to water its crops. So what happens then when the agribusiness, the big industrial farm, complains to the courts that the big manufacturer is taking up all of the water? As a judge, what do you suggest? Well, if you're thinking in terms of economic cost-benefit analysis, perhaps you suggest that the big industrial farm go upriver and buy the headwaters and then sell that water to the big manufacturer, which is a pretty novel solution to this problem. But this is something that the courts started doing in the 1950s as these nuisance suits proliferated, and this is very much outside of the realm of simply applying the law as it's written. So let's continue into Pioneer River in the 2000s. So I apologize for this typo. I'm going to fix it real quick so you do not get confused. So here is our same example of the Pioneer River, except now in addition to dealing with externalities and scarcity of resources, we're dealing with another issue that courts have had to deal with, which are very high transaction costs. So, due to adversarial legalism, as we know, it's super expensive for parties to engage with the American legal system and to file lawsuits and to see those lawsuits through either to settlement or to some other form of completion. So, again, Pioneer River. Down here we have Pioneer City. As you know, our population keeps growing, and so now, in addition to things lining the banks of the river, family farms, big manufacturers, agribusiness, etc., we now have a example of suburban sprawl down at the end of the river. Up at the top of the river, where those undeveloped land used to be, we now have a ski area. Over on the east side of the river, we now have a collection of private homes. So family farms have turned into private homes. Over on the west side, we have some very light industry, and over on the east side, just south of the private homes, we have an organic farm. And the farm has to be organic in order to make this a modern example. All right, so the ski area clearly uses lots of water. Private homes use lots of water. The organic farm uses lots of water, thus making water as a resource quite scarce. The light industry pollutes a little bit into the river, and so now what the courts are dealing with are multiple different parties. You have the ski area, you have the 4 private homeowners, you have the light industry, you have the organic farm, and we're not only dealing with the externality of pollution, but we're also dealing with the fact that all of these stakeholders require lots of water from the river. And when all of them engage with one another, we end up with super high transaction costs and complex lawsuits. All right. So to sum up then, 1930s, Pioneer River, we saw that the courts were having to deal with externality, right? They're starting to deal with pollution coming from our coal mine going down to the family farms downriver. But at this point, the courts were really not dealing with scarcity. There was enough water to go around. They weren't dealing with high transaction costs either, because you're dealing with a single group of plaintiffs who band together in maybe a class action lawsuit against the coal mining company. So fast forward to the 1950s, we're still dealing with externalities. So pollution is still going down the river and affecting stakeholders. But in addition to dealing with externalities, we're also starting to deal with this idea of scarcity, which is maybe there's not enough water to go around. Transaction costs are still pretty low because we're dealing with a limited number of stakeholders. But now, if you fast forward to the 2000s or our current decade, which I guess you would call the teens, we are not only, when I say we, I'm talking about the courts are not only dealing with the externality of pollution and the scarcity of water, but now they're dealing with super high transaction costs because there are just more stakeholders involved. And so this begs the question of whether or not we should think about complexity as another constraint on the court. So if you have a situation, especially in environmental law, where the courts are dealing with externalities, they're dealing with scarcity, and they're dealing with high transaction costs, that makes for a very complex legal policy-making environment. And so if you think back to question posed in step 3 a few slides ago, which is essentially, is the law well equipped to deal with whatever problem you're talking about? The answer to that question really quite often depends on the complexity of the problem. So how many stakeholders are involved? Is the problem ongoing? What expertise is required, etc.? So in other words, are there certain types of policy problems, and here we're thinking about environmental problems in particular, that simply defy ordinary litigation? And if that's the case, what should the courts do in the case of the Pioneer River? When we're dealing with the externality of pollution, they're dealing with the scarcity of water, and they're dealing with the incredibly high transaction costs of lots of parties entering the American legal system to solve these disputes. So let's continue to develop this idea of complexity as yet another constraint on the courts. So as we know, the courts are designed to address certain types of problems, discrete disputes that happened in the past in particular, and they're ill-suited to address others, such as ongoing disputes that not only happen in the past but continue to happen in the present, and will happen in the future, where harms are not discrete and nor are risks. So if we think of the courts as passive, then the ability to really understand complexity as a constraint becomes a little bit easier. So as we know, the courts do not choose which parties are present. So there's really no guarantee that all of the relevant interests will be represented. And here we can think of Versailles, the Versailles case, as a type of institutional judicial cant. So if you remember judicial cant from the Hurricane Katrina example, this is where the judge wanted to rule and argued simply to the plaintiffs that his hands were tied. And so here, in the case of Versailles, this is more of an institutional judicial cant. We can't guarantee that all parties who are affected by the GOV pile are going to be involved in a lawsuit. Also, courts are backward looking. So, courts, as I've already discussed, are typically designed to weigh competing views of the past that relate to specific causes of action. And here, the laws of justiciability come into play. Also, judges are trained as lawyers, right? Their expertise lies in the law, not in health policy, not in economics, not in environmental science, etc. And so the result of this is that when issues involve lots of parties, they involve ongoing problems and or issues that aren't clearly legal but may instead be health related or environmental related, the court's policymaking power will be constrained as the argument goes. So of course, what about the other side? We'll get to that in a second, but here again is summing up the constrained court view version of complexity as a constraint. So if you think of complexity as constraining, you're thinking of narrow disputes, broad problems, you're thinking of legal sanctions being really inapplicable to solving future harms and managing future risks. Potentially, the filing of lawsuits can lead industry to having a bunker mentality, and here this may mean that they resist complying with legal orders to change their behavior, and we'll get much more into compliance here in a minute. So the result of this is that some courts will shy away from acting entirely, and that others may act and may be actually pretty ineffective. So because we know that the constrained court and dynamic court view are simply a framework for looking at the same set of policy factors just from two different ways, it may be actually that complexity can serve to empower the courts too. And so here we see that complex problems equal really difficult policy choices for elected officials to make. And so as a result, members of Congress and other elected officials are incentivized to pass the buck to the courts, right? So members of Congress think about that river or the Pioneer River in the 2000s example. Member of Congress might look at that and be like, oh my God, there's so many stakeholders here. I don't want to spend the time, the money, the political capital, and the resources to worry about crafting a solution to this problem. And not only that, I might inadvertently piss off a lot of potential voters. So I'm just going to say, look, courts, you handle this. And so thus you see that policymakers are incentivized to pass the buck. Complex problems also lead to a realm of policy uncertainty. And so here the courts can actually be pretty effective because the courts, by definition, rule on a case-by-case basis. And so we can see, one court in one sort of area deals with a case in a certain way, another one deals with it yet a different way, and this can show other courts and other policymakers the merits of dealing with these really complex problems in different ways. That if Congress, for example, was passing a law that would affect everywhere the same way, we might not be able to understand. And then finally, courts are not always limited to the traditional forms of adjudication, such as one party paying another, or remedies. So courts can be sort of creative in what they order parties to do, especially in a really complex policymaking environment. So quick digression into the policymaking world. So we can think of private policy problems versus publicly centered policy problems. And these lead to really different responses. And so I kind of want to go through the logic behind thinking through this for a second. So of course we have private and public responses split here or private and public centered disputes rather, not responses. So the remedies or the ways that stakeholders can deal with private-centered disputes are two ways: through engaging in private contracts and through filing lawsuits. So one private entity, perhaps a corporation, filing a lawsuit against another one, or a collection of homeowners filing a lawsuit against a company as well. This can be really, effective. Like if we're thinking back to the 1930s Pioneer River example with only two stakeholders, but this can be tough if there are lots and lots of entities involved. So on the other hand, if the dispute is public-centered, there are a lot more options. Quangos, which are quasi-non-governmental organizations, are one. So the Federal Reserve is an example of this. That doesn't necessarily deal with environmental law. Also, um, the state simply engaging in a monopoly over the resource that is at question. So here, the Pioneer River. The state taxing businesses or farms for consumption of the resource, so consumption of the water. We also see, and this is an example of cap and trade, if you guys have ever heard of this, the state could publicly auction off water rights. So in other words, the agribusiness could bid for water rights against the family farms, against the ski area, etc. Or the state could engage in some sort of bureaucratic creation of a panel of experts who dole out water rights based on some predetermined criteria. And this expert model can be discretionary. So in other words, the experts are left to decide the best way to do this, or it can be rule-based. So I'll come back to these concepts in just a minute, but I wanted to introduce them for now. So the either the last or the second to last bit of reading in today's assigned reading in the Judicial Policymaking Reader is this excerpt from this book called Shades of Green. And there's a good chance if you did the Shades of Green reading, you might be reading it and wondering kind of what it has to do with our class. This is a normal reading, but hopefully I'll be able to shed some light on that here in a second. So if you think about the courts and if you think about regulation, so in other words, either the courts or Congress or whoever trying to make stakeholders act a certain way, it's important to note that regulation doesn't just happen. So Shades of Green talks about this example of pulp mills. And so this is the creation of paper products. And so they talk about how in these two cases, we see that the courts tell these pulp mills that they cannot deal with their sort of environmental byproduct dioxin in a harmful way. And so we see that there is a couple of different pulp mills. So they're underneath the same law, right? Which is this requirement that they have to do this certain thing with the dioxin. It's the same type of business. They're both pulp mills. They both are dealing with the same type of technology, right? Which is causing this unwanted byproduct. Yet the law, as Gunningham shows in Shades of Green, has enormously different impacts based on the business. All right, and so I'm gonna expound on this in a second. But we see this all over the place. We see it in environmental law. We see it in employment discrimination law. We see it in the Americans with Disabilities Act, etc. We see it all over the place, that businesses that look similar, right? Organizations that look similar, that are operating in the same industry with the same technology, sometimes even in the same state or in the same city, comply with regulations completely differently. And so this underscores a super key point that kind of provides one of the impetuses for the way that we think about the law in this class. And it's that what the courts say or what regulatory agencies say, they must be put into action at the ground level. And understanding the way that businesses construct the meaning of the law is at the heart of what judicial scholars call the law and society movement, which is something that we've been skirting around in this class a lot, but is what is essentially is what this class is about. And the key notion here is that law and society radically decenters the study of the law, moving from the courts and the legislatures to actors at the community level, especially organizations. And I'll explain what I mean by that in just a second. So Gunningham in Shades of Green talks about how there are different approaches that businesses have when they're dealing with the government or a court or whoever telling them that they have to do something, right? So they have to stop polluting. If it's the Americans with Disabilities Act, they have to put in curb cuts so that people in wheelchairs are able to navigate from the sidewalk to the street. They have to have ADA compliant entrances to buildings. They have to have elevators in any building that is above a single story, etc. So at the end of this spectrum, the negative end of this spectrum, Gunningham calls these organizations laggards. And these are organizations that ignore or entirely resist the law or the regulatory requirements. Next, he talks about reluctant compliers. And these are organizations who seek to do simply the bare minimum under the law. And then he talks about committed compliers. This is a little bit more positive. These are compliers who take the law seriously, and they seek to go beyond what they believe to be its bare minimum requirements in order to create a margin for error under the law so that they're not running afoul of these regulations. And then finally, there are true believers. And these organizations not only take the law seriously, but in fact, they see the underlying goals of the law as part of their core business goals and the right thing to do. So rather than a company simply paying lip service to the idea that diversity is important in the workplace, they actually make it a core component of their business, right? Or a company, rather than simply doing the bare minimum, says, in terms of ADA access, right, Americans with disabilities, they say, look, this is what we're all about. We are all about access. We're going to go above and beyond and really put this as part of our mission. So this brings up what Barnes in the Judicial Politics Reader calls the socio-legal model of looking at the way laws are translated into outcomes on the ground. And so bear with me here because this can be a little bit complicated, but I think that if we go through it slowly, it'll be a little bit easier to understand. So we're starting with this field that we call the institutional field. So here we're dealing not necessarily with people, but we're dealing with political institutions, we're dealing with business institutions, business organizations, etc. And so it's important to note that in some of your other legal studies courses at TWU, you are going, if you haven't taken these classes already, and here I'm thinking of constitutional law in particular, you're going to simply, in these classes, talk about formal rulemaking. And so here, this is this policymaking process between the Congress, between the president, between the courts, and between agencies. And this is really the focus of most constitutional law classes at the university level. It's really the focus of a lot of political science in general, right? So if you want to know what the law is, you study what the law says. You study what statutes say, you study the Bill of Rights, you study what the Constitution says, right? This is fine. This is a fine way of going about things. However, what law and society scholars say is that it's simply not enough to study what the law says, because we know that in the American judicial system, judges have so much leeway into thinking about how to apply the law, right? That just studying what the law says doesn't matter. And not only do judges have a lot of leeway in applying the law, but non-judicial actors have a lot of leeway. And so here we're talking about businesses for the most part, but other types of organizations as well. So these formal rules then, you can think of this, as Barnes writes in the Reader, as a kind of fountain that has spillover effects. So at the top you have the formal rules that spill over into businesses or other types of organizations. And so Gunningham writes in Shades of Green about 3 different licenses to operate. And here these licenses to operate essentially provide businesses with a rationale for accepting regulation or accepting formal rules or really internalizing them or shunning them and not caring about them, like with laggards, for example. And so there are three: the economic license to operate, the regulatory license to operate, which is where we often find adversarial legalism, and the social license to operate. And the economic license to operate essentially talks about the economics of complying with formal rulemaking. Regulatory talks about whether or not they've internalized the need to comply with regulation, and the social license to operate talks about the sort of but the sort of cultural or community-based factors that may lead to compliance. So all three of these licenses to operate, when you combine them with the formal rules that Congress and the courts, the president, et cetera, create, they all funnel through individual companies that have individual management styles. And that once this happens, we are left with outcomes on the ground. Okay? And this is kind of a difficult concept to think about, but it's something that we're going to keep reinforcing over the next few weeks, right? But just to go back, thinking about the formal rules, right? What the law says, as Shades of Green argues, is not enough. As with the paper mills, right? We're dealing with, we see two different businesses, same technology, same law, same state, et cetera, et cetera. Yet one of the businesses does what the law says and the other one doesn't. Why does this happen, right? It's not enough then to just look at the law and say, wow, well, look, Texas has really strong environmental laws when it comes to pulp mills. Because on the ground, one of the pulp mills is not complying with the law at all, right? So how strong is the law? So that's where Gunningham and other law and society scholars bring in these non-legal factors, right? These licenses to operate, as well as management styles within certain companies. And this is when you get to outcomes on the ground, right? So this is when you get to a business deciding to comply with the ADA. So to sum up, why do we care about the socio-legal model? Well, we care because it demonstrates that management styles can be a certain type of cultural constraint on the court. And this is one that stems from the organizational targets of the law. So if you recall the story of the landlords in New York, this is from early on in the course reading. Remember, they felt like they had no incentive to get these windows fixed, right? And then a little girl or a little boy, I can't remember, but fell out of these windows. It was a terrible thing, but the landlords felt no need to comply with the law. Also, the example of the Americans with Disabilities Act, which I've just talked about. So as for some questions to think about as we move forward, what is an externality? What is the problem of scarcity? What are transaction costs? How has the American approach to regulation changed over time? What are the strengths and the weaknesses of the sort of new American approach to regulation, one that involves the courts in a really heavy way? And then finally, how does complexity constrain the courts, or how does it potentially empower the courts? And I said finally, but now I really mean finally, what are the various licenses to operate? And these, of course, stem from the Shades of Green reading. So regarding last week, summing up the dynamic versus constrained court view regarding tort law, the dynamic court view argues that tort law has been pretty pliable, and the courts have been able to move from this idea of a reasonable duty of care to proximate cause. We talked about these shifts last week. These are really vague terms, and they lead to laws that are left to the courts to interpret. And yes, courts are passive, of course, that internal institutional constraint, but as the readings demonstrated and as we talked about last week, before the rise of widespread insurance in the United States, people turned to the courts with a flood of lawsuits to deal with tort issues because there's simply no other remedy, right? Of course, the flip side of this is that the courts are actually constrained when it comes to tort law, and that doctrinal innovations, so meaning changes to the law, they were simply concerned with and reflective of the dominant concerns and economic interests of the specific times that we studied. So, for example, in the 19th century, the courts were operating in the shadow of the Industrial Revolution, where their main goal was not necessarily to advance the law, clarify the law, compensate plaintiffs, but instead was to protect industry. Fast forward to the 20th century, this rise for total justice, as Friedman writes about, has really taken root, and thus the courts change tort law so that rather than protecting industry, their main aim is to provide compensation for Americans that expect total justice. And so one could argue that this is so summing up then the dynamic and constrained court view with respect to regulating environmental risks and regulating hazards. The dynamic court view argues that doctrine is vague. So like the tort of nuisance, for example, this invites judicial discretion, meaning it gives judges some leeway to rule. And it also gives them essentially an invitation to make policy. So there's hardly any constraints on the court in this respect. There also exist, as I've mentioned, political incentives to pass the buck to the courts. So you have legislatures passing the buck, and the result is that courts are often in the middle of defining policy responses to environmental risks. In addition to this, the social license to operate and some management styles may actually amplify the law's effects. So, for example, a company that exists in, I don't know, the Bay Area of California, they're going to be pressured by the community to maybe be a bit more progressive when it comes to providing access to people or not harming the environment, etc. And so as a result, they might think, okay, if we want to sell our product to these people that live in our community who hold these views, we better internalize these values ourselves. So think about, the liberal nature of Whole Foods, the grocery store. That stems from a specific place, right? Whole Foods, of course, is from Austin, that seeks to internalize, and as a company, they really seek to internalize the values of the place where they were founded. On the other hand, the constrained court view argues that there's simply a structural mismatch between adjudicating disputes in an orderly way, right? Orderly dispute resolutions, and really broad multi-dimensional problems. So the Pioneer River in the 2000s, for example, where we're dealing with externality, we're dealing with scarcity, and we're dealing with high transaction costs, and that the courts simply lack the expertise to deal with these issues. And so as a result, the courts are likely to defer the policymaking process to the other branches, or if they do act, they may in fact be pretty ineffective. And that economic licenses to operate and some management styles might dampen the law's impact. So again, thinking about these licenses to operate, the economic license to operate might say, look, we're a small business. We want to comply with these regulations. We want to comply with the Americans with Disabilities Act. We want to make these changes. However, if we do make these changes, it will put us out of business because our operating margins are so thin, we simply can't afford to put in an elevator. We can't afford to put in a chairlift so that somebody in a wheelchair can get to our loading dock. If we do that, it will put us out of business, right? So whereas social licenses to operate might amplify the law's effect, it could also be argued that economic licenses to operate could dampen the law's impact. So that's all we have for today. Some of these concepts I realize are going to be a little bit new and might be confusing, like the socio-legal model. We'll continue to develop them, and we will talk about them at length in class on November 14th. So please feel free to email me with any questions. I believe you have discussion board answers that are due on November 14th as well. And so I will see you in class next week. Thanks a lot.